Hey, what's up, guys? I've got a doozy for you today. The prosecutors in Kyle Rittenhouse's case up in Wisconsin are demanding the names of every single person who donated to Kyle Rittenhouse. Now, they're saying that they're doing this because that would disqualify them from being on a jury. I think their purposes are a little more nefarious. Let's figure out what's going on here. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, go ahead, hit like, hit subscribe, turn on those notifications. Don't miss any videos, okay? All right, we're talking about Kyle Rittenhouse. He's the kid up in Kenosha, Wisconsin, who ended up shooting 3 people during some mostly peaceful, fiery protests that were going on following the shooting by an officer of Jacob Blake, a shooting that was deemed to be fully justified for a whole host of other reasons that I'm not going to get into right now. So, Kyle's trial is coming up in November, which is, man, we're getting through this year pretty quickly. That's coming up. And prosecutors have said they're now demanding a list of everybody who's donated to Kyle. Now, they say this disqualifies them as jurors, and a donation to Kyle Rittenhouse may show enough bias to disqualify a juror. The problem is they don't need a list of every single donor. They don't even need a list of every single Wisconsin donor. Heck, they don't even need a list of every single Kenosha, Wisconsin donor. It's very unlikely, all told, that many individuals in the jury pool will be donors. And those jury pool members can be asked during the process called voir dire. That's where a lawyer stands up for each side and asks questions of a prospective juror to try and determine if they are qualified to stay on the jury or if they need to be removed. And the court gets to make its say on that too. If the court finds an overt showing of bias, they can dismiss the person, or the lawyers have a certain amount of no question strikes that they can do and to strike jurors. The idea is to get a fair jury. So there's no reason to have a list because the prosecutors can simply ask every single juror, did you donate to Kyle Rittenhouse? Because the defense attorneys are going to be asking similar questions. Did you participate in any of the Black Lives Matter protests in 2020? How about 2019? How about 2021? Did you burn down a gas station? Did you loot a pump and munch? Whatever it is, did you take a bunch of stuff from an Apple store? They're going to ask these questions to jurors to see if they are qualified, because if they participated in protests, they're going to be probably biased against the guy who shot some protesters. So they want to know those things. The prosecution should be doing the exact same thing. What they don't need is a list. Now, here's why they really want a list. It's pretty simple. Because the list can leak, and people know it can leak, and that's the whole thing. We've seen people who have donated to Kyle be socially, politically, and employment ostracized for their donations when those donations became public through some various actions that occurred. We saw this happen. We saw journalists showing up at people's houses. We saw social media posts about these particular donors, people going after their employers. This is an intimidation tactic through and through. They want to strangle off the money supply for Kyle Rittenhouse. They want to make it known that it is not acceptable to donate to this person. They want to choke off the potential jury pool if they can. Not through the real means of saying, is this person biased or not? They want to force people out. They want to force people out of their political and personal beliefs on this thing. And this is part of the same bogus prosecutorial tactics they've been doing the entire time. Making up allegations about Kyle being associated with white supremacy, lying about hand signals that he was making or things that he was saying. Trying to get him thrown into prison when he didn't belong in prison, when he had not violated release conditions. Prosecutors in this case know this is a political case. They're very afraid of losing it. It should never have been brought in the first place because everything in that complaint says that this is a justifiable use of deadly force, and they know that their case is extremely thin. That's why they're doing this. That's what's going on. And it's absolutely bogus for the government to be demanding lists of its political opponents in a lawsuit. And you know the only purpose that they're doing it. Look, I'm going to flat out say it. These prosecutors have engaged in prosecutorial misconduct before, and they're willing to do it again. That's it. Maybe that's a hot take. I don't care. Tell me what you think down in the comments below. Catch you next time. Peace. Peace.